You agree to buy a friend's Baki for 50,000 rands. There is no paperwork, just a handshake. The next day, they turn around and sell it to someone else. Are you legally entitled to sue them? Most people assume a contract requires a physical document filled with legal jargon and signatures. In reality, a contract is simply a promise that the law is willing to enforce. But the legal system doesn't enforce every promise. Under South African law, an agreement must satisfy 8 specific criteria to cross the line from a casual promise into a binding contract. If you don't know these 8 requirements, you have no way of knowing whether a court will actually step in to help you enforce a deal, or if they'll just show you the door. Consensus is the first requirement. One party makes an offer, the other accepts. Both minds must meet exactly. You also need serious intent to be legally bound. No court will hear a breach claim for a missed dinner date. Intent must be commercial, not social. Next is contractual capacity. This shifts the focus away from the promise itself and onto the legal standing of the people making it. Take an unemancipated minor under 18. Under the Consumer Protection Act, supplying goods to them is voidable without an adult's consent. Missing capacity creates a power imbalance. The minor can escape the agreement without penalty, but the adult supplier remains locked in. The agreement must pass tests of legality and possibility. Contracting for a crime or selling a burned-down house disqualifies the deal. Then there's certainty. Vague terms like a fair price fail. The agreement needs clear, measurable terms, like exactly are £10,000. One of the most persistent myths is that every deal requires formalities, like a signature or a notary stamp. In truth, verbal agreements are perfectly valid as the default rule. However, specific laws will occasionally override that verbal default. For instance, the Consumer Protection Act allows the minister to prescribe specific categories of consumer agreements that absolutely must be reduced to writing to be valid. If your agreement fails on how it was made or what it's about, the legal system strips its protection entirely, rendering it commercially useless. When an agreement fails the checklist, it falls into one of 3 distinct failure states. The first is a void contract. Because of a massive flaw, like illegality, the law treats this agreement as if it never existed at all. The second is a voidable contract. This is an otherwise valid agreement containing a fatal flaw, such as being signed under duress or by a minor, which gives the victimized party the unilateral option to cancel it. The third state is unenforceable. The agreement actually exists, but owing to a specific rule, like a missed deadline under the Prescription Act, the court system simply refuses to process it. Let's test this framework. Imagine a 15-year-old verbally agrees to buy a stolen PlayStation from a classmate for a good price. Run that exact scenario through the 8-point checklist and identify exactly which failure state it lands in.